Ten Commandment litigation had been going on for decades and not very well. And we had this case coming out of Utah where this little town, Pleasant Grove, wanted to fight back. And this group came in to say, well, if you're going to display a Ten Commandments monument, we want you to display our monument, which was called the Seven Aphorisms, which were basically the anti-Ten Commandments monument. The idea being, if cities are forced to do this, they'll be putting them up all over the country and cities will just remove their Ten Commandments.
I suppose it depends on what the government speech consists of, what it is the government is saying about the Ten Commandments. If the government is saying the Ten Commandments are the Word of God, that's one thing. And if the government is saying the Ten Commandments are an important part of our national heritage, that's something else.
And precisely, Justice Scalia, that's exactly what Mayor Cook, in fact, at the unveiling ceremony stated, that this will serve to remind citizens of their pioneer heritage and the founding of their community.
Do you have to say this? Did the NEA Finley versus NEA, the court didn't treat that as government speech,
correct.
Did it? Is that the...
No, you're correct. Those were speech selection cases, and I think it clearly that the actions here of the government, the City Council, falls neatly within Forbes, Finley, and the plurality American Library Association.
Because you don't have here a 40-year history of this monument being there, and nobody seems to be troubled by it.
There's a 36-year history here. This monument's been on display since 1971. So this monument's been there a long time.
Yeah, I think 38 is the cutoff.
Is that the cutoff?
Yeah.
Perhaps I miscounted. It may be 38. This is not a monument standing alone. There are 15 other displays in this pioneer park.
Is this a challenge to the Ten Commandments monument?
It's not.
This is not an Establishment Clause. Did not involve an Establishment Clause challenge.
There is no Establishment Clause. It's not a basis upon which the injunction was sought, and the Tenth Circuit specifically held it was waived.
Whether it's the government stating the message, or whether it's the government creating a limited public forum for the presentation of only those messages that it thinks are important, it comes to the same thing, doesn't it?
Well, it depends on if it's a limited public forum, certainly limited public forums can be based on subject matter and speaker identity. This court said that consistently, Cornelius and Perry. So in that context, and now that limited public forum appears to be more of a non-public forum type of analysis, certainly, even in a designated public forum, it could be limited in that regard. This court has a depiction of Moses holding the Ten Commandments in the frieze of the courtroom with words written in Hebrew. That's not an endorsement of the religion or of the commandments. It's representative of the history.
And I said it, basically, if it's good enough for the Supreme Court of the United States, it certainly is good enough for Pleasant Grove. And 9 justices agreed with us. It was a great decision and a great result. It's rare you win a Ten Commandments case, and it's even rarer to win it unanimously, and we did, by God's grace. It was a great victory, still is.